caja working. Oh, he needs to put her on. There you go. Okay, so we start by company management. Who manages the company? Who's responsible for management of a company? The directors. So when we speak to a person being appointed as a director, I always told you that they have a duty. And that duty in being a director is enshrined in law. So if I say the right hand is going to do company, the left will do IBC, tell me where it is, where it says what's the duty of a director. This side is company, that side is IBC. Where is it enshrined in law that the directors have a duty? What, 45? You in part 4?
Yeah. No.
No.
Is it 55 for IBC?
55?
For IBC.
Let me see.
And then I have the old version.
You're the old one, eh?
Me too.
No, that's 55 speaks to liquidator
55?
in the new one. Read your section.
Okay, every director, officer, agent, or liquidator of a company's performing its functions shall act honestly and in good faith with a view.
Oh,
to the
yeah,
best
that's
interest,
55, yeah.
of the company.
So that's 55.
Mhm.
So what is it in the Companies Act? Found it? No, I didn't want to
81.
You have the old one too? Yeah, you have the old one, you have to get the new one. I thought you got the new one, I think it was some last lots.
Only one.
Only one person got that.
Oh, you got it, it was you it.
Yeah.
Okay, so I need to make you a set.
That's one.
Okay, so it says in both, every director and officer of a company, in exercising his power and discharging his duties shall, A, act honestly and in good faith with a view to the best interest of the company, and B, exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. That's the duty of care of a director and an officer. But I also want you to note, go to, under the Companies Act, it says, under the same section, subsection 3, every director and officer of a company shall comply with this act and with the articles of the company. So not only do you have a duty of care and skill, you also have the act. The act actually stipulates that in carrying out your function, you have to comply with the Companies Act and also with the articles of the company. So the note says, a director is a person appointed by the shareholders to formally manage a company and ensure that it achieves its corporate goals and discharges its responsibilities to stakeholders. One of the main responsibilities to stakeholder is not just making sure that they gain a profit, but that the company is in compliance with the legislation and with the memo and acts. That is key. It should be noted that the Companies Act does not specifically define a director. So if you go to the very beginning of both legislation, where they actually give you the terms and conditions, at the very beginning, look at the definitions. In section 2, A, B, C, D, there's no director under the Companies Act. Under the IBC Act, is a director defined? Go to section 2,
No,
it's not defined.
no.
But even though they are not defined, they legislatively tell you that as a director or an officer, you have a duty. In both pieces of legislation. It says that you have to act honestly in good faith, in the best interest of the company, but keep bearing in mind the unanimous shareholder agreement and of course, the memo and acts. Directors are also required to exercise the duty of care, skill, diligence, and skill that a reasonably prudent man would exercise in such position, whether as an executor responsible for the daily operation or as a non-executor acting independently. So whenever you become a director, it's not about what you can gain for yourself or how you can profit. Everything has to do with what's in the best interest of the company. It's not even always in the best interest of the shareholders, the company, because the company is a separate legal entity. And people normally get that mix of that, oh, okay, I'm making this money for the shareholders. You're making this money for the company, because shareholders get dividends. And dividends declared based upon whether or not you're making a profit. So you're not actually working for the shareholders. They have invested in the company with the hope of attaining a return. But you're actually working for the company, what's in the best interest of the company. So as fiduciaries, directors have a legal duty to act in good faith, not make a profit from his fiduciary position, not place themselves in a position where their duties as director conflict with their interest. And like I always say, behemoths don't understand what the word conflict means. You cannot put yourself before the company. Act for their own benefit or the benefit of others. And they don't understand the word others, even though a lot of them are attorneys. Because others mean not others, they mean others. All your friends, all your lovers, and anybody else who's closely related to you, whoever you are connected to or known to be connected to, is a part of others. Because it is a conflict. Without clear, unequivocal consent from the principals of the company on whose behalf they act, whenever there is a conflict, whenever there is something that is not addressed in the memo and acts, you have to get consent. And that consent is given without you being present. Unless everybody around the table said, guess what? The person can actually be present, but they are not allowed to vote. They cannot speak. They can be there, but they are not voting, nor are they speaking. You must act in accordance with the memorandum and articles of association. And again, I told you that's the role of the corporate secretary. The corporate secretary guides the chairman as to what he can and cannot do. And deal with and treat fairly the different classes of shareholders. And we went through all the different classes before. So when the decision is being made by a board to go in a particular direction, they have to consider how will this impact the different classes of shareholders. So let's go to appointment of a director. The first directors of a company are appointed at incorporation of the company. Is that enshrined in law? The first directors of a company are enshrined. Is that enshrined in law? IBC, Companies Act. I hear breathing, but no answers. Does it say that?
The first directors of a company, 42.
Mm-hmm.
The first directors of a company shall be elected by the subscribers to
There
the
you go.
memorandum.
Mm-hmm.
And thereafter, the director shall be elected by the members of such terms as the members may determine and where permitted by the memorandum of the
Right,
company.
because the question always asks is why there have to be two subscribers and then you have to have the first meeting to appoint the first one. And the act actually stipulates that that is the process that you follow. So the first are done by the subscribers, where? Okay,
Because mama's the old officer.
okay, what you have?
Which I'm not gonna know which it is.
Okay, 89, I think that is not in the IBC Act, that number, I think get you the new one.
Yeah.
Read that again, because that wording of that has changed. What it says on your 89?
Director name and the notice referred in subsection holds office as director of the company from the issue of the certificate of incorporation of the company until the first meeting, any meetings of the members of the company.
What number that is?
I don't see that in here, in the new one.
I see 80.
Hold on. Oh, I see it, yeah, it's 42, subsection 2. That's only saying holds office, hold on. Yeah, 42, it's just IBC Act. Yeah, 42. 42, subsection 1, for the IBC Act. And then for the Companies Act, what section you say, 80 what?
89,
I don't see that.
that's the new one.
I know you're in the old one, I'm trying to find it in the new one.
84 for company.
At the time of sending articles of incorporation, the public company registrar shall send them in approved form. The notice of being consented to become director, so the registrar shall file a notice.
Yeah.
That's the only thing it has. Yeah, I don't have it. Not the clause what she read. Nope. How many directors are required for a company versus an IBC? Two for company and one for an IBC. So when you're appointing a director, what should you be mindful of? What document? Or what two documents?
The article.
The articles and? Two documents. No. No. Two things. The articles and unanimous shareholders agreement. The shareholders agreement limits how many directors the board can appoint.
Articles on,
The shareholders agreement. The articles of association normally specify when and how a board may fill a vacancy for a director, appoint additional directors up to a maximum number, or remove a director. So go to your table A. Remember when we went through the articles? The one that can actually just be incorporated without reprinting it. What is it, how does it speak to filling a vacancy at a board? And she don't have it either.
I mean,
Yeah,
the
but
first
I-
schedule,
Yeah, that's the act, but when I say go to the articles, at the back, here,
okay.
I just speak about filling a vacancy.
Any casual vacancy occurring in the board of directors may be filled by the directors, but the person so chosen shall be subject to retirement at the same time as if he had become a director on the day on which the director in whose place he is appointed by last elected a director.
Which, section you reading? I'm trying to look
Because
at
hold
it.
on, because that was rotation of directors.
No.
And duties.
That's rotation.
Mhm.
Yeah, they speak to rotation. So what does the act say?
We're filling a vacancy.
Mm-hmm. Go to 87 subsection 2
For company,
of company, and then the IVC.
I think this is 42.
Oh, man, now. That's the meeting notice, quorum, alternate, single. No, let me see. No. It just said in 44-8 that a notice of change shall be filed. No. Or 42-3A. A director shall cease to hold office or director if a majority requests his resignation in writing, and then he may resign by giving written notice of his resignation. Under the Companies Act, it says, where the holders of any class or series of shares of a company have an exclusive right to elect one or more directors, a director so elected may only be removed by an ordinary resolution at a meeting of the shareholders of that class or series of shares. Subject to subsection 98B, a vacancy created by the removal of a director may be filled at the meeting of the members at which a director is removed, or if the vacancy is not so filled, it may be filled pursuant to section 89. So what's section 89 and what's 98B?
B is fill a vacancy among the directors by the office of auditor.
Mm-hmm.
And you say 89.
And then section 89.
Subject to subsections 3 and 4, a quorum of directors of a company may fill a vacancy among the directors of the company, except a vacancy resulting from an increase in the number or minimum number of directors, or from a failure to elect the number or minimum number of directors required by the articles of the company.
And if there is no quorum of directors, or if there has been a failure to elect the number of, or minimum number required by the articles, the directors then in office should forthwith call a special meeting of the company to fill the vacancy, and if they fail to call a meeting, or if there are no directors then in office, the meeting may be called by any member. So the Articles of Association normally specify when and how a board may fill a vacancy for a director. Appoint additional directors up to a maximum number, or to remove a director. So you notice when you read the articles at the back of the Companies Act Table A, you see how vague it is? So like I said, you can either adopt it as is. In most instances, they tailor it. They tell you how many directors based upon your unanimous shareholder agreement, and they also tell you the procedure for selecting and removing a director. So they can put their own requirements as to when they want someone removed. On appointment, a new director should sign to signify his or her consent to act as a director. Execute a director service agreement. Obtain the relevant insurances and indemnities. So we can stop right there. What insurance or indemnities do you get as a director? What should you get? By law. You have an indemnification. What is that indemnification? As a director. Once you sign on as a director, what indemnification are you entitled to by law? You have to go to the act. You see why it's so important to do a course. Depends on what you're getting into, because you sign on as a director and you just assume that these things exist, and you don't even know the extent of the coverage if you don't know the law. So what is that coverage?
A company may indemnify a director of the company, a former director, a person who acts or acted at the company's request as a director or officer of a body corporate of which the company is or was a member or creditor, and his legal representatives against all costs, charges, and expenses reasonably incurred by him in respect of any civil, criminal, or administrative action or proceeding in to which he is made a party by reason of being or having been a director or officer of that company or body corporate.
And then the Companies Act?
That's the company, sorry, no, she's not.
Okay. Indemnifying directors. Is there indemnification for officers?
Yes.
Okay. So what is it under the IBC Act? 58 speaks to insurance, and 57 speaks to indemnification. (57) 2A speaks to indemnification. So when you sign on as a director, you sign the director service agreement, which normally includes your emoluments, right? You obtain the relevant insurance and indemnities, and you normally ask the company whether they have their own professional indemnity insurance to see if you're included in that also. And then you have to ask for the corporate documents. You have to read the memo and acts. And a lot of people don't do that. Details of the business and financial affairs of the company. So you should normally be given by the corporate secretary or by the chairman via the corporate secretary a package. And what should that package include? When you become a director? If you were going to be appointed today as a director of Acopio, what should you receive? First thing is your agreement. What would be stated in that letter?
Fees,
The fees, uh-huh.
term, terms and conditions of your position.
No,
No.
they don't tell you that. Why won't they tell you your terms and condition?
Because that should be an article, right?
It's in the articles,
Okay.
and it's statutorily stated.
Okay.
Once you become a director, you have a fiduciary duty. So it's fees, frequency of meeting, the venue, if it's set, the time, and the next thing we're going to come to, the type of director that you've been appointed to. If at the same time you're going to be appointed to any special board committee, they will say so too, at the same time. And again, they'll have the frequency, the venue, and the time. Okay? What's the second thing you should ask for, or you should obtain?
Copy of the article.
The copies of the articles. Three. What else should you obtain? Financial statements. And remember, you don't want just the last financial statement or annual report. You want to go back, because you want to get a clear picture of how the company was performing. And so most instances, you go 3 to 5 years. What else should you ask for, or should receive? You could have a look at the insurance coverage. Mm-hmm. Anything else? Review board minutes and the resolution book. You won't get copies of it, so you have to make an appointment so you can read it to see what decisions were made and what were discussed. You would also want package of all previously approved policies and procedures. And you would probably want to get a summary of all major contracts. And what we call third-party suppliers. So you're not just appointed and you just attend the meeting. You have to come with the information already in your head, with the questions that you want to ask based upon what you have observed in the minute book, in the financials. Now, if you are appointed for a particular reason. So say you appointed because your expertise is accounting, or your expertise is in economics, or you are an environmentalist. They expect you to come to the meeting to bring contributions from that aspect. Because that's the purpose of putting you on the board. So generally there are two types. And if you, hold on, and another thing is if you are really a good director, you should know, which is what we did last time, what? Last class. What should you know? What should you ask? Shouldn't you ask that?
Yeah.
Is the company compliant with all statutory filings? You are a director. You're responsible for the company. And a lot of directors don't ask that. And then come to find out when someone making a presentation somewhere down the line, they say we were late and we had to pay a fee. Or when the accounts are presented, you say, well, what's this extra fee here? Saying registrar, late fee, penalty, what does that mean? But as a director, you have a responsibility. Even though there's an employee somewhere down there whose job that was, it was your responsibility because you're supposed to know when things should be filed. Even though it's not your job, you're supposed to know as a director. So there are generally two types of directors from an operation functional perspective, an executive director and a non-executive director. Executive director who works full-time in a company and is responsible for the daily operation, strategic planning. And then the non-executive, and that's the person who doesn't work full-time, who's appointed based on some expertise that they're going to bring to the company. Now, when we speak the company law, we don't say she's non-executive and she's just a director. In company, you're just a director in company law. Same fiduciary duty. The difference comes when you read your letter. When you read your letter and we say we hereby offer you the position as a non-executive director. So in your mind you know that you are a director, but you don't work for the company. But you have the same fiduciary responsibility, you have the same liability, you have the same indemnification as those who are directors. Because it's one term, director. No difference. People like to throw that around, I'm just a non-executive director, I'm not a director. It's a director. Same responsibility. Both executive and non-executive directors have the same legal duties, responsibilities, and legal liabilities. No difference. In addition, you have nominee directors. Remember I say whenever we speak about this nominee, the nominee is a creature that is normally done in offshore centers, who are personal or corporate directors appointed to act as directors on behalf of another person under a corporate management agreement or a nominee directors agreement. So we spoke about that before, where you have a company whose purpose is to provide directorship service. So the company then acts as a director. And then you have shadow directors, who are persons or entities who by operation of law and their conduct in relation to the management and decision making are considered directors. They're not appointed. It's by their actions and decisions. The law will say they are a director. So I have it, even though they may not have been formally appointed as directors and may be acting in a different capacity or role in relation to the company, but based upon how they act and the decisions that they make, the court may determine that they are a director. In law, there's only one word, director. But in everyday practicality, we have types of directors. But in law, it doesn't matter which one it is. It's the same liability. Always remember that. So if you are a member of a company, or you are an ex-board member, but you still act as a director, how a director should be acting, you are exposed to the same liability. So shadow directors are not defined in law until recently in 2011, and you can find that in the Companies Act and the IBC winding up legislation. So it says a shadow director is any person in association with those directions or instructions the directors of the company are accustomed to act. That means that someone else is telling them what to do. Not the directors themselves are doing, someone else is telling them what to do. But the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. If a person or entity is considered to be a shadow director, they are liable for all legal obligations and liabilities of a director duly appointed or acting in the traditional sense. So normally the courts determine whether a person is a shadow director. Once a court determines that you are a person whose actions and instructions the whole board actually depends upon, then you're looking for your winding up thing.
Yeah.
Then the court will say that you are a shadow director. The decisions of many English cases have indicated that the test as to whether a person or entity has real influence in the corporate affairs of the company to be deemed a shadow director is whether the real influence reference was wielded over the corporate governance of the company. And you know what I mean when I say corporate governance of the company? How the company is actually run. Or the entity identified as such a director, particularly if it can be shown that he acted as equal footing with the duly appointed formal directors. That's why you have to be very careful. If you have a person who's always calling the meetings to give advice, and they find in the minutes that based upon what this person constantly deliver and deliberate, that the board normally follows, then by reading it over and over again, each minute you begin to say, is this person a part of the board? Because of the influence they have in the decisions that they make. And depends that if one of those decisions one day turn out not to be a good decision, and they go before the courts, then the courts will probably determine this person is a shadow director. They act as if they are a director. They have influence. They sit around the table at every meeting discussing these strategic positions, and at the end, based upon the votes that we see in the minutes, they were carried, and they will put them as a director. And once you're a director, then you have the same legal obligations. The recognition and judicial treatment of shadow directors under English common law and Bahamian legislation is to protect the stakeholders of a company from the management of companies by unelected or non-appointed persons or entities, particularly those who wield unsolicited and overreaching influence over the corporate governance and general affairs of the company. And my pet peeve is always this: we have government ministries run by permanent secretaries, and they have a minister that's appointed. But what's the role of the minister versus the permanent secretary? Who runs the government ministry? Day to day, the permanent secretary. You see the difference? So even though you may say that is government, this is a private sector, the general terms of company law still apply. If you want good corporate governance, then those who run it have to be responsible. They are responsible for the day-to-day running. Not the permanent secretary says A and the minister says M, and then the people in the middle do what they feel like doing. They're the ones that run the ministry. The same way when you go to a company, the shareholders should not be intervening. They gave a shareholders a unanimous shareholder agreement. The management runs the company. If they're not running it properly, then what? Who you go to? The directors. Because they have a responsibility. So we go to BPL. Where's the problem? You have the shareholders, you have the board, you have management. Where is the problem? Who do you see speak out the most? This is the managers. You only heard about the board when we heard about the replacement.
Oh, okay.
We heard from who? Management. Who does the management report to? The board. So if there is a problem, the board needs to deal with it. So why every time there is an issue, we keep hearing from the union representative? This is what you call good corporate governance. Who should we be hearing from? We're the consumers, we pay you. Who should we be hearing from if there is a problem there? The board. The board needs to tell us what is going on, what is wrong, what is it you need, not the union. The union is there for the people and their rights. We're not interested in that. We're not doing employment law. We want to know why our bills are high, and the chairman should know. And if he doesn't know, he needs to go to his management team. That's a response. That's good corporate governance. When you're in the part of the board, that's your job as corporate governance. You set the strategic plan and the direction. You're responsible whether the company makes a profit or loss. And you are directors, you have a fiduciary duty. And we're going to go through those duties right now. They should be answering to us. But the problem we have with that too is we're not stakeholders, only as people of the Bahamas, because it's a government entity. So indirectly, they do owe us an explanation, because it's our money that's funding it. But the chairman of the board should be speaking to us. So have you heard yet why it is 70%? Why has it gone up?
And they said something, but,
How can it be an error if you heard that they have increased the exemption from $200 to $300?
yeah, they increased it.
So why did it go up to 70%? Don't look at what social media says. What did the chairman say?
The document is from BPL, stating that it's not going to.
So then why did the government increase it from 200 to 300?
They haven't been paid by the Cuban and they say they gone from 2 to 300.
And then you have someone else coming and saying, another citizen saying, well, my bill was the same. You see what I'm saying? Good corporate governance.
BPL, they say BPL said something, said it didn't really.
That's what I said, I saw.
Yes,
Facebook
yeah,
this morning.
right, okay, so a company has
But
a
then we
press
shouldn't be
liaison,
guessing.
that's a part of management.
Yeah.
But when you have all of this confusion in the market, the chairman needs to
Needs to
speak.
voice it.
Yes,
Yeah.
the one of this.
You shouldn't be on your guessing.
You shouldn't be guessing. If it's not the chairman, then it should be the general manager. When the general manager
Fuel charge higher
speaks,
than the light bill.
yeah, he speaks with the consent of the chairman. If I am the general manager and I see all of this, he must have the same thing everybody else is getting on their phone, right? So he hears this, it's this and this is it. He knows it's not the truth, right? The chairman picks up the phone, there is a problem in the market. Straighten it out. Send me a draft of what you're going to say. So when the general manager speaks or the CEO speaks, he speaks on behalf of the chairman of the board. Because that's who he reports to. So if the chairman is not going to speak, then the general manager or the CEO should have spoken on behalf of management and the board. This is what it is. You don't have that. Everybody flip-flopping. No one wants to stand up and take responsibility. But what they don't realize is that all of them are responsible. So that's why you see when you fire the chairman, you fire the whole board. Because they're all responsible. They all have a duty. You can't point the finger and say, no, it's that one. No, it's that one. No. All, collectively. Because if I figured that she was a problem, we should have voted to have her removed. And replace if necessary. But you cannot at the end of the day point your finger at one person. Because you could have had that person removed. So as a director, you act as fiduciaries. Boy, is the scent smell good and that don't smell good?
Garlic egg.
Like food.
What's food for? This ain't food now. What is this?
That might still be foolish.
They make candies downstairs, some kind of candy things. No, that ain't no things. No, they make candies.
They call
That's
me.
how they cook it. That it tastes good. Directors act as I don't know what that is. As fiduciaries for the shareholders of a company and custodians of his assets. So think about the directors and on any board. You are responsible for the assets of the company. Assets can't go missing and you turn around for the union to speak. Assets cannot be damaged and you trying to figure out what happened to it. You have a responsibility to the company.
That's actually saying all this, right? And I think some of these boards ain't equipped properly with these directors.
There you go. That's my point without me saying it.
Yeah, because I mean,
When you
look
get
at-
appointed to a board, yes, some of them are government appointments. In some companies, they are my friends,
Mhm.
whatever. But what people don't realize is that because we're not like other countries, we don't sue. You see what I mean? You have a responsibility.
Because I mean, some people honestly who you see on these boards, you wonder
Clueless.
how they, what do they bring to the table?
Not only do they bring to the table, but have they done their homework?
Yeah.
And if you are not in the market, let's just say you got picked right now to be on aviation board. What do you know about plane?
Not a thing.
What do you know about the regulations?
None.
You see what I'm
It's like
saying?
that to me, be quiet and then get my check at the end of the quarter.
Then that exactly what happened to all the rest of the places.
Yeah.
Or other
No
companies,
value.
they fall down. If you don't have the right people sitting on the board, it will fall down. Because you don't know what's going on. You don't even know how to ask the right questions because you're clueless. But you have a fiduciary duty by law. So the first duty is to act in good faith to promote the success of the company, not the success of your pocket, the success of the company. You shouldn't be trying to be figuring out ways in which you or your family or friends can benefit. Yes, it's not about that. It's the company. That's how they're supposed to think.
They trying to sell they could get rid.
Right. To act in accordance with the company's constitution. That's why you get the memo and arts. A duty to act in the best interest of the company must always be in the best interest of the company. Exercise reasonable skill, care, and due diligence. If you're dealing with a matter and it's before the board and you all realize that guess what? None of us know anything about this. You seek an opinion. And then you make a decision based on that opinion rather than guessing. Duty to exercise independent judgment. When you're taking a vote, everybody must consciously consider it and vote based on their conscience. And when you base in your conscience is what is in the best interest of the company, not you and not your friend. So let's use, for example, the post office. Is that in the best interest of the people of the Bahamas? Mm-hmm. Where going this time? No.
Going to the,
I mean,
Blue
it's
Hill
Town
Road,
Center Mall.
Town Center Mall.
But no.
Well, Town Center Mall.
By Phil's, they
Yeah.
scratched that.
They scratched that.
that.
Cost too much.
The building wasn't a good.
Was not in a good condition. So is it in the best interest of the Bahamian people?
If it's their location, yes, size, yes, but because he's a minister, and if it's a conflict, should he be
Now,
receiving a
remember
contract
now.
as being a government?
It's like anything if you're in a private company. If you're in a private company and we're all on the board, I'm the chairman. We need to buy some furniture, some special retrofitted furniture because most of our employees are disabled persons, let's just say, right? She has a company that sells those, right? Everybody else have different ones where they're gonna have to fix it, do this, do that, order this, order that, but she has two there, samples that are perfect. This is the problem we have to address now. Because the people we have now are all complaining that the regular desk is hurting them, they're getting back problems. We know the condition. We know there's a need for it. She sells it. So we weigh it in. Should we go here? Should we go there? Should we order there? What's the time? What's the cost? Right? So you look around. The best place left after we didn't look at before Phil's, they look at other places before. This is not the first time this has come up. At the time it would have come up earlier, that mall was booming. Right now it's empty. So now it has become an item that you can use it. It's available. It's in a central location. It's indoors. It's not like when you go to the main one, you're outside in the night, you can't go after 6 o'clock, you get robbed. At least it's inside, you can park. If it's raining, again, looking at the people, you can go in and still go and get your mail. So that's one thing. The problem now is it is owned by a sitting minister. She is the sitting minister. She is the one who's selling us the furniture. But after we've analyzed it all, hers is the best one to get. We don't have to fix nothing. She can, with her contact, she can have those two desks with us within a month. The other people for 6 months, a year, they have to fix it, send it here and send it there. This is the best. Let's ask her what price she can give it to us for. When we look at the price is okay. What the board does, they said, we're going to consider your proposal. You have to leave the board meeting while we deliberate. She leaves. Decision is made without her. At the end of the day, if all of us agree, looking at everything, that hers is the best one, we award it to her. Conflict of interest is when she stays and becomes a part of the conversation in the turn to convince us. Now, she can stay if she doesn't speak. She can stay, she can sit there, but she's not a part of the deliberation. The minutes will not reflect that she had any conversation with us to influence us.
But why leave her in there? Like, I think he was in there when they was talking in the house about it. Why even? Because my thing is that because of the person that he is, even though he's not a part of the voting, why even allow him in there while the discussion would?
As long as he doesn't speak.
Yeah, but I think too, I think people could be intimidated.
But don't forget now, he too is a lawyer.
Does this fall
So he
under his
knows.
ministry? No, right?
No.
No.
So he knows there's nothing wrong with him being there as long as he doesn't speak. He's not influencing anybody. Sometimes they normally ask you to go out. I don't think you have that kind of influence.
You don't see it, people say
You think people are going to
Yes.
be scared
Yes.
that they vote no? For
Yes.
him? No, I don't think so.
Yes.
He's been through this before.
Does that make it?
He's been through this before.
But the
When you all make noise about him paving the roads, you see the condition he in now? We're gonna move from having these potholes fixed by these things to the technology that they use in other countries. But no. Just like any other business, he needs to make money in order for things to improve. Now, if you don't want him, who's the alternative? You see what I'm saying? You have to look alternatives. Do you want to bring in another company, the ones that did the road, where the roads up the sidewalk so high you gotta climb over it? You see, you gotta think of these things. You don't want to give it local, but you want to go foreign. The people who don't know the culture and the way in which we do things, and you pay the price at the end of the day. Because when they realize that, oh, this is a land of milk and honey, they keep extending and extending and extending and extending and
My
extending.
whole thing, I don't
It's a go.
issue with him, with the contract to say, because to me, just like, if you declare and say, okay, he didn't hide the fact that he
No, he
knew
didn't.
this or whatever, I don't have a problem. I just felt when I saw it and I saw the debate, I just was saying from his end, I would have just not be in there. I didn't see why he needed to be
You probably
in
say he has
there.
nothing to hide. He has nothing to hide. You know it's his own. He declares his assets. There's nothing to hide.
I mean, that was just my thing. I just was like, why? would
Trust
want
me,
to
if
be
you
in
didn't
there?
want it and you are a director, you have a duty to speak up. So you're a member of parliament, you sit there for your people. You see, what I don't see happening here is when these things are being debated, those ministers are supposed to go back to their constituency. What do you think? Because sometimes there could be some place that everybody miss. And someone could come and say, guess what? If you're not going to physically go to them, then you have emails or whatever, some box where you could send an email and say, did you all consider this place? It could be a place no one considered. You see what I'm saying? But did anyone have an alternative? Were there any alternatives? I don't have any or any. There was none. The only people came on was talking about how much it's going to cost to retrofit. No matter where you go, it's going to be a cost to retrofit. Because this is not a blank building you want. It's a post office. So these are the kind of decisions that people always have difficulties. It's just, okay, let's take another kind of business we have around here that does something. What else we have around here that actually makes something? Besides the water people. Yeah, the soda people. Okay, so let's just say that they moved. They used to have plant out Prince Charles, now they're down this way. So if you're on the board, what would you have to think about moving from there to there?
Traffic flow, big movement.
Clientele,
Mm-hmm.
location.
Mm-hmm.
The spacing along, because I think when they were Prince Charles, all them trucks and all of that, that was inconvenient, and then that's before even the road works.
Mm-hmm.
So being accessible to the customers.
Mm-hmm.
Parking.
Parking is minimal.
Noise and all that.
Noise, pollution, profits. You see what I'm saying? Those are the things you have to think about. But before we even get to that, that's the nitty gritty. Who are we buying it from? And who are we selling that to? That's what you have to think about. And if that person was a board member, that we were going to now relocate there, now you see it's the same issue. It becomes a conflict of interest. So then whoever in management is presenting it have to say, guess what? We need this square footage in order to move. It has to be retrofitted to put all of these machines in it. It must be this height. We must have 5 exit doors by law because of the type of work that we're doing. You see what I mean? We must have access for 5 or 6 trucks to come in and load. And the gate this wide in order for it to come out. Because of the weight of the trucks, we need this, this, and this. These are our options. And included in one of them is one of the board members. Looking at what's in the best interest of the company, forgetting that that person is a board member. You look at the proposals before you. Which one is the best one? At the end of the day, if hers is the best one, that is the one they will choose without her being present.
I think it was just personal for the people.
That's what I'm saying. The people keep mixing it up. What's in the best interest of the company or what's in the best interest of the country? And some decisions are hard to swallow, but it has to be what's in our best interest. That building's supposed to have been, what do you call it again, imploded almost 30, 40 years ago. Think about it. Yes. They were talking about that from when I was small. When I first was working at the Central Bank, every day I look and say, oh God, I can't wait to see how they're going to do it. It never happened. It's getting almost 50 years. You know how long that is? It's an eyesore. We have to move ahead.
They still have persons in there, right?
They work half day, just doing the meal part of it. And then a place like that attracts stragglers. What you have to do is to try to move the locals access further to where they live, as this is a tourist industry. Like, I don't see why all the pensioners go downtown to BOB on Shirley Street. Why? They should stop it.
All of them?
They all line off.
Down Hall Road.
You need to see, you know when this pensioners day,
Yes.
because they line off on Bay Street. No leg, one crotch, alcoholic, why? And when they get it, they buy liquor. So they're sitting on the benches where the tourists should be sitting when they're tired, and they're carrying on. Why are you coming downtown? Your bus could stop anywhere around there. Go there. But it's a mindset. I tell them go home. I don't try to be said to be mean, but I always say what's in the best interest of the country. It doesn't look good. There's a new man that just started. He's by the Hilton. He stands up by the statue. drunk every day. And the tourist is passing in, and he doesn't behave. And he's standing up on the statue where the people want to take a picture. Come on now. The security at the door at the Hilton must have seen this man, because I see him. Why can't you call the police and have him removed? The ambulance will come with the gloves on and they will take him away. And he's just walking up and down there for the past week and a half. You can't be that blinded if you're looking at what's in the best interest of your company and the country. It's your company. Because you're not, even though you may say you're an employee, right? And you have management, and you have the board, and you have shareholders, we all profit together. And that's the mindset you have to have.
Yeah, but I think in Minister Simonett's case, why I say it was personal for the Bahamian people is because it appears that one person just seems to be profiting.
Mm-hmm.
And the Bahamian people are not, there's no ultimate benefit to the Bahamian people, like give someone else a chance. I think that's what the conversation was, you know.
Okay, but
That's
then
why
like I
it's
say,
personal.
what were the alternatives?
I know, but it's
Yeah,
not an alternative.
but that one is alternative, right?
Yeah.
Now, if there were other alternatives that someone else or two or three other people had buildings, maybe a little bit further, maybe the rent or the lease was cheaper, then I could see everybody making a bunch of noise. But what were the alternatives? None came.
And they said some of the city market, some of the.
Which one?
With the,
What?
Independent?
That?
they were saying
That
that,
is no, it's too low.
Independent?
you know, they had Independent and the one by, I think off East Street or something.
Oh,
Yeah, they were saying, say why
Oh,
I did
there's
not.
nothing in that. They ripped that apart. No,
But they were
no.
saying that, you know,
No.
just, say
No.
why can't you rebuild or, you
No.
know, they were coming with
No.
stuff like that.
Who's going there?
I'm just saying,
Who's gonna go down that hill on East Street in the night to go to the post office? Seriously? No. Come on. You think of the safety of the people.
Now, let me tell you, don't sleep on Town Center Mall area either, you know,
It's nice.
because I could tell you, I worked at that branch. Don't sleep on that area. That's one branch,
That's why you need police.
we coming out
But
before
that, but that
nightfall.
place what you're talking about, you need a pass when you leave this class.
No, I just saying,
There's
I
nothing
know,
there.
I know people are saying that, but I'm just saying,
Yeah,
Town
there's
Center
nothing there.
is not as safe as people may think.
There's no area around here
Yeah,
safe.
but you know, I can
None.
tell you.
There's none that's safe.
Mhm.
But that building, that old city market by East Street, there is nothing there. So tell them don't even try it. You
I
see
didn't
it?
talk with that, I
They
just
started
wanted to
to
tell
work-
them.
They started to work on the one
Cause-
off.
Yeah, that
Highland
one.
or something.
Yeah, don't try it. What next one you want? The one off
No, I think they just
Village
spoke
Road?
about it too. No. Oh, yeah, Village Road.
Yeah, no, nothing happening there either. They
What
might as
happened
well
to the
just
village?
implode them. Nothing.
They, the government, they
They
want
all
that.
that go to bowling alley used to be there now.
Mhm. Yeah.
And then
I have a solution, you know. I think I'm gonna put it to government. All these buildings that are on commercial property that the people are not doing anything with, we give them an ultimatum of 6 to 8 months to do something with it or take it.
Mhm.
And that's how we could revitalize this country.
I thought that's what they were gonna do, is a strip on here. when
Me
they
too, they didn't
started.
do it yet, but I
Yeah,
pushed
that's,
for
that was
it.
the ask, my thought
Take
process
it.
to take it. 'Cause it-
Draw
you know
another
what
map
happened with them. And
of
they
the
stopped
rezoning.
It stopped midway with
It
them,
wa-
and
the
they-
rezoning what happened in 20 years,
It's
right?
midway.
But as people move and as time change, you take it. And then you rezone them in the areas that are going to be rezoned for residential area. And you just rezone it. So someone comes here 75 years from now, it's a totally different place. That's what we have to do. But it all calls for change in mindset
And no political interference.
and no political interference. You see?
But something like that would come under the tax regulation.
Yes, ma'am, you gotta pay
To
my
go and Pay
taxes.
your taxes.
That's
so-
my class I just been to, they got depressed, so no one talk about that.
Oh, sorry.
Not me, damn, they got, I just telling them how to tax.
'Cause I think that's what it was.
I can do that from tax, I'm telling you how to tax.
You have to tax.
We have to tax. With the amount of things that we have to do, we have to tax. Where else are we gonna get the money from?
'Cause property tax, so.
And it starts with culture. You change the mindset of people. You don't pay your taxes, you know what will happen. But when people believe they can get away with it, they continue. Then they drop dead. They don't care. They're gone. They left it with you. Well, Daddy didn't do it. I just live. When I die, it's somebody else's problem. And that's what happens.
That's a disgrace on them, though. How you think you could be living in the house and you don't get no
Yes.
mortgage on
No.
it for the last year, and then mad that people
More than a year.
No, 3 to 5, I think.
Yeah, more than that.
More than
So
that.
then-
And they pay. They
That's
must
okay,
they
that's
take
okay.
them out.
Mhm.
So
They
they
should
kick
take
them
them
out?
out long
They
time. Yeah.
go on the court, take them out.
Mhm.
So but they want to stay.
Yes.
Mhm. They want to stay because they were staying for
And
the
they
last
said they
year.
know the rights, and they know they already sent them a letter telling them that it was overdue for such amount of years, and they just didn't care to pay it.
Mhm.
And
And I say again, it's a cultural thing.
They feel no way, no embarrassment.
No,
No,
no.
they gonna
They
try
had
to
an
say
interview in the
no.
Tribune. They had an
Yeah.
interview in the
And
Tribune.
on TV.
And on TV, they
Exactly.
said put it back into
Interview.
the house to get clothes.
Had
Oh,
an
that's
interview in the
The
papers.
daughter and the.
Mhm.
And then
Okay.
and
Yes.
he's
And the
saying how
mother,
they
that's
call
what
the
I heard that
minister or
Yeah.
somebody.
What you calling the
yeah.
minister for?
They can't influence.
And then
you
break
didn't
in your
read
house
that?
afterwards.
No, that
Get
was in the
clothes.
They
paper.
break in your house. And so they lock you up.
Yeah,
Crazy.
they were actually on television
No shame.
admitting that they didn't pay it
No shame.
and looking for pity.
From me.
And again, you see what I'm saying? If you were on the mortgage corporation, if you were in senior management mortgage corporation board, right? You know that it's for lower income persons. Fine. But you see what's happening with the commercial banks. They don't give you no break. They follow the law. Yes, you're the mortgage corporation. I know you're for lower income. You must have some discretion. But look at what they did. They themselves give all of their clients time. They did restructuring and all. Time. And then what happened? What did shareholders say? Enough is enough. Board, get this in order. Board tell management, write the policies in order. Sell it. Because we are at a loss. And so when they saw that the commercial banks took that approach, because we were all in the same recession, they should have started the same action rather than having a delayed action. You ain't paid, send out notice. This is what it's going to be. Come in, restructure, give you a chance. You can't restructure, your house going up for sale. Otherwise, who lose? We lose, because that's our money. They loan our money out. So we get another loss again. You see what I'm saying? You see how you have to look at it. Yes, she up there talking, but that's our money she just spent.
They say almost $1 million, right?
That's our money. Now, whether or not they took that money out of NIB, it's still our money.
And NIB.
So I always use this class that's to tell people it's a government, it's not a company, but think about it. All the money that they're operating with is our money. Because we're all citizens of this country. And you have to speak up. So because they think it's our money, that's my share, they're not paying. But it's all of our money. And if you don't pay, we can't fix the roads. See this building here? It should have been knocked down years ago. That is not a historical building. In no shape or form.
It's clean though.
They just painted it. You need to look inside. No,
See, I just
not
said
that. That.
Which one? The peach one, right?
Yes, that. That is not an historical building. Look at it. Does it look historical to you?
No.
Yes, it's a law firm.
I just say that, they make it
Yes.
for the painted, right? 'Cause
That
that's
is
what's
not
on
a
that.
historical. They did that to make it look good. Yes, that is not a historical building.
Has that been around a long time too?
Does it look historical to you?
Well, not, no.
No, it doesn't. It looks colonial? No.
No.
It looks like a house they added to and added to and added to. You know, it's just certain things. If you have a building on
Zoning.
certain streets,
Zoning.
you need to have them painted. If it's not painted, you'll be fined. And we add that to the year. Yes, seriously.
The
Where?
yellow, the big yellow building down the road that's supposed to be a museum, right, not too far from there.
Yes, yeah,
It's
the
not
old
open,
Collins
right?
Wall,
Yeah.
that owned by government.
Right, cause it's not open, it's not even, they don't have that open to tourists.
That's
Well,
a
I mean,
historic
it's
house.
the old
It's just-
museum.
Yeah, it's sitting there.
Mhm.
It's not too far, sir.
It's the old, what, Collins house or something?
Yes, Collins House.
Yeah.
Who built the Collins Wall? You know what the Collins Wall is?
Who better say you're talking about?
Oh,
Well,
she
Shirley
don't know your
Street.
history.
Where's she talking about?
She's
There's
not
a
too far from
on
Shirley
Shirley Street, right in front
She's
of,
young.
just before you go to,
old Shirley
if you're
Street,
coming
yeah.
down Collins Avenue, this Doctor's Hospital, on your left is
they
the
renovated
Collins
that?
House. Yes, they did.
Yeah, a long time ago, right?
No.
No?
No,
And that was
Shirley Street,
Ministry of
yeah, it's going
Education.
further
No,
down.
that's, oh, okay.
After
I
the
know, I know the
bridge.
yellow building where they had the museum thing.
No,
Yes,
the theater.
yes.
Oh, I know, but the theater.
He was
Yeah.
Thompson, Thompson Trading.
But they
Yeah.
moved them into
Yes.
the building that's
Yes,
crossing
ago.
all the
Oh, I know,
public.
that's
Yeah,
on top of,
yeah.
yeah, the doctor's hospital. Oh, okay.
Yeah, there's a big
But
house
they've
there in
been
the
doing
back.
a lot of functions there. I thought they renovated that building.
I don't know what functions, but
Yeah,
that's a
they-
historic building.
Yeah, they've been having a lot of functions
It's
there.
our history. The wall that separated the blacks from the whites.
Oh,
Good
I
one.
did not know about that.
The wall
House.
still exists.
Where is it?
What's wrong with your people?
It's a white person live on Shirley Street.
It's
Shirley
Collins
Line.
Avenue.
On Collins, go on Collins
Yeah.
Avenue, turn through the corner where IBM used to be.
Yeah.
Yes.
You see that wall?
Oh, it's that wall.
That is
Yes.
called the Collins Wall. It's separating whites from blacks.
Yeah.
What? Oh, I didn't know that. Sorry.
That's your
I saw the
history.
wall, but I didn't
You know
know
the
it
school
was about.
that's right on the corner?
Yeah.
Collins, when you go Collins Avenue, you hit Wolf Road.
Yes.
That school was on the side.
Yeah.
That was the city dump.
What
I
that is,
didn't
Stephen?
know that.
That's the city dump.
It used to be the city dump.
That's
Oh, I
Stephen
didn't
dump.
know
What that is?
Whatever it name.
Columbus?
Columbus.
Yeah.
Let me
You
not
don't know
I
your
call it wrong
history.
name. It's been a minute.
It's been a minute, but this one was lost. I'm telling you.
Like quiet.
I lost for sure. I
That's
did
the-
not
that's the
know.
history. I
remember
But I
that,
never
but I
even
didn't-
looked. I
it's
knew,
so
I
sad,
saw
but-
it.
You see that wall? That is
Yeah, but I
history.
never, you know,
So what you mean the whites and the blacks?
bang, lang.
Like,
I
what
never-
you mean?
The white people used to literally live on Shirley Street, the whites and the people back in the day.
I know, but I mean, like, they live
Yeah, I know.
on this
Some
side
white
and the
people
whites
said
live
that
on
on
that side.
Yes,
Literally.
yes, yes, literally.
Literally.
I thought I
Literally.
was all mixed up and I came along, so I.
No, literally. Yes. That's why you see
I
certain
know, but I
people are
teach in Anna
concentrated in certain parts of the island.
Right.
Blacks stay on this side and whites stay on that
Even on
side.
the corner in Palmdale, you will see the white people still in that little area.
Yeah, and even on what the road, Mackey Street?
Yeah,
Market
they
Street.
still
Uh-huh.
have
Right,
that
right.
same
They're
little
still in that
area.
area.
When they own that area.
Uh-huh.
Yeah.
Mm-hmm.
Yeah,
Literally.
yeah,
Right,
yeah,
right.
they stayed in
Yeah,
those
right in the
little
back,
pockets,
right where.
but they were separated.
Right there.
That's- You notice now, we move into their part. They never came over to us.
No.
You're really nice now, you want me to share?
No, they won't
They
come.
ain't want
They ain't
come.
come.
And
They
they
never
mad
come.
that we come in there.
Mhm.
Right,
they bad.
exactly.
Mhm.
And as you start, as Bahamians got more affluent and move into theirs, they move out.
Mm-hmm.
Yeah.
But I
Yeah, I
just
know,
knew.
but
I
paid
never
that much
know.
attention. But at least I know the
I don't know
building.
what they teach you all in school.
Right, and
They
I
call it
really don't-
Bahamian history, but
And
I
I
don't know
just
what that
want to
is.
say,
It's
I
a
remember
wall
that
down now.
They didn't talk
History.
about
History.
that was
No, I don't remember that
international
understand.
history.
Yeah, that's what I said.
What
US
about you?
history.
Yeah,
US
European
history.
too.
That's not even it, but they're
Yes.
talking about this island.
No,
What?
I know.
Only
They
Columbus.
And my daughter 13,
And
I
after Columbus,
remember
on the
talking
Hispaniola,
about that.
that's what it.
That's what they teach
Then
me.
you went on to where all
And
those
the
oil
English
and
adventures.
stuff.
They
Yeah.
talk about the
Yeah.
little
First
science, the
Who's the
hour.
first governor?
Rogers.
Roger.
Am I wrong?
No, Bush Rogers. And who was Bush Rogers' mentor? Who taught him how to run this country?
I want to say it, but I'm scared.
Say,
Stop. Stop with us?
no.
No, I don't know.
You don't know?
No, who?
The mentor of
Yeah.
Black Bear.
Black Bad.
Yes, right.
Him?
It's in history.
What's that? Him?
His mentor taught the first governor.
And Black Bad, how, what's this now? And Black Bad place out there, like, oh, these?
Yes, right.
Okay. Oh, you can't get to that.
No, they don't allow you to.
Because there's a bush now, the
There's a lot of
track road.
bush.
Yeah.
It's not too safe.
Those houses on Eastern Road protected, eh?
From what?
like in terms of doing this construction to them, they have to maintain the building. They can do renovations from out of time.
I know, so you can't get there, so?
No.
Oh, okay. No, I know the corner.
Embassy, not too far.
I think
Yeah,
that's
one of
Brazil.
the
It's a
Brazilian
Brazilian
Brazil
embassy.
embassy.
Yeah.
But I think of the track that you could get through.
So you have to know your history.
It's a bush.
But they don't
Just
teach
think-
it.
They
Just
didn't
think
teach
about
history like that.
a lot of what our politicians do now is inherited from the people that ran it before.
Mhm.
Think about it. Only thing we did was go to England to get the Constitution to be free. Because they said, you know, we want to get rid of all these colonies, all this responsibility. But the people, and they sent people here to run these countries. So if you send me as a white person to run this country, with a bunch of little black people running around, I need some help. So who I gonna ask? The people who were in charge of it before. I know where they pirates. Yes, pirates. Pirates. And that's why they became gangsters and all the water was become gangsters because that is how it's run. You have to know your history. Anyhow.
I don't think we should make some that kind of history.
Honestly.
Yeah, because honestly,
And
they,
them said that they teach them
Yeah.
US history in school.
US?
US history.
US
But you know what, and them little social
European,
study
you know.
book, but they them little flat ones, it must cost
Yeah.
for $50 and get 10 pages and it's from the government. I sure none of that in there. None of that. And we do them ourselves,
No.
that wall is not in there.
And now they're learning in the Europe.
I guess they don't want y'all to know.
They ain't want, no, I don't remember
No,
that.
that ain't it, honestly, I don't know.
Depends who making the book.
And
Yeah.
that's what I'm saying, but these are the Bahamian books, they publish it, they Bahamian books.
But you notice they always say when you read certain books or certain parts of history it's not written
Sure, sure.
Yeah.
because it's controversial.
And then nowadays, you don't have Bahamian teachers, a lot of them,
No.
you know, so you have the foreign teachers, so they're not.
So who built the water tower? Yeah. Black people from this side.
It's right up there.
Black people from this side. This side of the wall. Chop these same rocks. You
On
see
this
around
side,
here.
the black
Yeah,
people.
The same, the
Because this
same
side
side
is
we
the
on
white
right
side.
now.
Okay.
No, the wall goes straight down this way. Collins Avenue that way.
Mhm.
So
Right.
East Street is black.
Right.
They chopped the rock to build the water tower.
How you know all of this stuff?
And the 66 steps.
You need to write a book.
Yeah, all of that.
Okay.
Hmm?
How you know all this stuff? The 66 steps.
My father was one of them, Who?
That's what they did.
Soul Rock,
They did the
to
whole
build a
thing.
water tower.
The 66 steps and the water tower.
My daddy used to carry water to the men who were building the Collins Wall. And my daddy also worked at the first airport. Where was that?
It wasn't all the way
Right
there.
by JFK. What's
Stapleton
the-
Gardens.
Yeah.
That was the airport.
Where?
Best Stapleton
Stafford,
Gardens is
Stafford,
right now.
What is it called? It's the Stafford something?
Yeah, whatever it was called.
Yeah.
That is where the airport was.
You mean where the sports center is?
No,
That?
that's-
No,
that's-
that was a
that's-
different
that's
airport.
different.
That was like a
Airport for the-
private
for the
one.
Private one.
You mean where the sports center is? You said that.
No, Stapleton.
No, go Stapleton Gardens where the homes are. That's the airport.
Oh, I was thinking the other one.
Cause she said by the statue, that's why.
By Simonet, what was it called? Simonet Airport or something like that?
I can't remember what it named, but that's where it was.
Okay.
You know where, when you go in, when they just did the new road?
Yeah.
Mhm.
So if you take the new road and you're heading south, the first one roundabout, all of that going that way was the airport.
Okay.
Y'all really don't know your history at all.
They teach me a lot of time and enough for those first airport.
What's wrong with y'all?
I didn't know that either.
I didn't know that either. Not to teach them.
Oh, and you know what I would've thought the first airport was?
Where?
The section in the back, like this, you know, the airport here,
The
where Bahamas their main
The
office.
old domestic?
No, where
No.
Bahamas their office was. I don't know if it's still there.
Where?
Like when you head into the airport and you go through the corner, instead of going around and roundabout to go towards the domestic,
Mm-hmm.
you head towards Carmichael.
Like if you had in the
The
Oh.
office is in the back there, that wasn't the.
That's general aviation
Yeah,
and
I thought that's
Odyssey.
where the first airport was.
No. No.
And then I think I was assuming that it branched where domestic was, but
No.
that's where the main
No.
airport was,
No.
and then you build into,
No.
international.
No. 21/7, y'all know your history.
Y'all didn't give us no
They ain't
book.
give us
Y'all
the
scared to
notes.
write
Mhm.
it and we'll read it and understand it.
Mhm.
We
Please.
scared.
So to whom are the general duties owed and who are their beneficiaries? In common law, the duties of the directors is owed to the
Company.
company. Only those who are able to act as or on behalf of the company can enforce the duties. And only those who are able to act as or on behalf of the company can enforce the duties. Peskin versus Anderson. Distinguish between the fiduciary duties owed by directors is the company which arises out of the relationship between a director and company, and fiduciary duties owed to shareholders who are dependent upon establishing a special factual relationship. And we've already discussed how that interrelationship is between management, directors, and the shareholders. By whom are the general duties owed? Those who have been properly appointed as directors of the company. These are also shadow directors. As espoused in the case of Reed Smith and Fawcett Limited, directors must act in the best interest of the company and cannot use their powers to benefit themselves or third parties. The legal test of whether a director has in fact acted in good faith is one in which a director acts in good faith in what he believes to be in the best interest of the company, notwithstanding the fact that his decision may in fact also promote his own interests. However, directors must also exercise their powers for the purpose for which those powers were given. It's not enough that they simply act in good faith, in which they believe to be in the best interest of the company. Directors as fiduciaries must exercise their powers prudently and properly and act in good faith, not just in the best interest of the company, but also in the exercise of their powers, corporate, discretionary, administrative, and otherwise. It is in the duty of directors to exercise their powers for a proper purpose, that courts fairly and objectively monitor and assess the propriety of the decisions and actions of company directors. And this is so particularly since the notion of what is actually in the best interest of the company is more a subjective test and is arguable, more suitably determined by the judgment of directors who operate and manage their companies within the parameters of proper and appropriate ethical behavior. Directors must be seen to be exercising their discretionary powers independently and fairly in matters, particularly those involving their shareholders and in contractual relationships with external and internal parties. And we've discussed all of that. Whilst the case of Motovix versus Bullfield established that directors do not have a duty not to place themselves in a position of conflict in and of itself, they should not place themselves in a position where their personal interests or duties to third parties conflict with their duties to the company for which they are acting, without clear, unequivocal consent of the company. Directors may be given such consent in the provision of the articles or by an ordinary resolution of the company. As a corollary to the principle under which the conflict of interest of directors operate, directors are also prohibited from gaining a profit or obtaining some benefit by using proprietary information, trade secrets, or opportunities that may belong to or derive from the company from which they act as directors. Nothing is more peeving to a shareholder where someone from management leaves and then starts up the same business, taking the clients. That should not happen. And there should always be a clause in the contract prohibiting you from doing that after a certain amount of time. Section 84 of the Companies Act and Section 40 of the IBC Act stipulate the duty of directors, but it changed, to manage the business and affairs of the company. So I did it backwards instead of forward. So one of the primary duties of a director is to treat different classes of shareholders fairly, particularly where to do so would be in the best interest of the company. In the case of mutual life insurance versus rank organization, it is imperative that the shareholders of the company as one of the primary stakeholders within the corporate governance regime, be treated fairly in the proper distribution of dividends where applicable. The allotment of shares, access to company information, and in corporate decisions made in accordance with the company's memo and arts of association. So you have a duty, not just on how the company is run, but even when it comes to declaring dividends. You have that responsibility also, and to take into consideration all the different classes. Since directors are generally responsible for management, they may exercise all the powers of the company. However, directors do not have unlimited powers to run the company on behalf of shareholders. They can only exercise their powers within the law or by the articles of association or the shareholders' agreement. The ambit of a director's authority is restricted by the Companies Act or the IBC Act and the articles of association. Because remember, in the articles, it actually tells you their borrowing limits and what they can and cannot do. The articles of association also entitle the board to delegate powers to individual directors as considered appropriate. Directors must act collectively as a board to bind the company. So any breach of any of the duties will amount to a breach of the director's duty to the company. As a general rule, the director cannot be liable for the fraudulent, criminal, or bad faith acts of his co-directors if he hasn't taken a part in such act, and he has no knowledge of it or suspicion of them. However, if he is involved in such acts, he is jointly and severally liable with his co-directors and may be required by law to make good the whole loss with his contribution from his co-directors, except where he misappropriated by himself. Directors may be liable to account for any secret profits they may have made, and in such case, the company will be entitled to avoid any contract it may have made with him. So this is where you enter in a contract with a company knowing that your wife or your son is a shareholder of that company and you didn't disclose it. Additionally, any company property that a director may have taken or transferred to a third party may be recovered by the company, except in the instance of a third party. The property was taken in good faith and for value. You know what that means, right? This is when a director sells the property of the company to an individual, and the individual didn't realize that whatever they sold was the property of the company. If you knew that the person was selling you something that belonged to a company, then you're going to be sued also. Because then you hold that property as a trustee, a constructive trustee, on behalf of the actual owner. But if you have no clue, and they sold it to you for fair market value, then it is yours. However, it should be noted that under the common law principle, in Bramford and Bramford, a company may by ordinary resolution waive a breach of duty by a director. Additionally, a court has the power to grant relief to a director who has acted honestly and reasonably and who, in review of the facts of the case, ought to, in the circumstances, be exonerated. Now, director's indemnification, we went to that after already, the section. With the ever-expanding ambit of directors' liability and risk posing a real threat to many executives and non-executive directors, many directors are seeking protection from liability and risk exposure from their companies and its insurers within the legal limitations imposed by statutory and common law. In granting such protection, particularly in instances involving impropriety, bad faith, or a clear and conscionable breach of director's duty. So it says right here was the first thing you have to look to see what's the statutory requirement, and then what coverage does the company itself has. Because sometimes when you look at both, it may not extend as far as you want it to go. So you have to know exactly what are your limitations in regard to exposure for liability. The statutory right to indemnification is only permissible to directors and their legal representatives of both statutes, provided such directors acted honestly and in good faith in the best interest of the company, and where they had reasonable grounds for believing that their conduct was lawful
in the case of criminal or administrative action. You notice those words keep coming up when you talk about the directors and officers, right? Good faith, honest, and in the best interest of the company. So since directors and officers may be personally liable to any party that may have an interest in the affairs of the company for damages, legal costs, and expenses in relation to a breach of a director's duty, many of them seek the protection of directors and officers' liability insurance. Directors and officers' insurance are designed to protect a director or officer against claims that may be made by a company, shareholders, or creditors. And you see the statute itself gives provision for insurance. So notwithstanding the provisions and protections of directors and officers' liability insurance, it is important that the directors ensure that they are properly and sufficiently covered when agreeing to accept and act in the capacity as a director of a company. You have to ensure that you have enough coverage for what you're going to do. Careful examination should not only be made of the coverage involved, but the extent of such coverage and the incidences and risks that are being included and excluded under such coverage. I know normally when you get a foreigner to be on a board, that's the first thing they ask for. Can I see the insurance? I want to know what I'm covered for. The negotiated settlement agreements of many executives and non-executive directors of Enron and WorldCom to make substantial personal payments beyond the coverage offered by their directors and officers' liability insurance in last year's securities class action litigation is a modern-day example of the limitations of personal protection from liability when acting as a director. Prospective and newly appointed directors would be advised to seek an independent advice and review of the indemnification and insurance coverage offered by a company and the extent of their personal protection against any claims and actions and proceedings. Since directors and officers cannot rely for protection on the separate legal personality of their companies, as enunciated in Solomon versus Solomon, and protections provided for the company's assets in respect of reimbursement of directors and officers, indemnification and insurance coverage should be a primary consideration in the exhaustive list of requirements of a company before accepting to act as director. That's how you know how many people write a chapter. The increasing number of claims of shareholder and creditor litigants, the rising cost of litigation, and the personal assets of directors that may be at risk should encourage companies and directors and their advisors to work collaboratively with audit and corporate committees to ensure not only compliance with internal legal and regulatory requirements, but also sufficiently comprehensive legal and financial protection, particularly for directors and officers who maintain the gatekeeping role, risk, and responsibility of the company. Because what you don't want is to act in a role as a director or an officer and come to find out that you're being sued and there is no coverage. General statutory duties do not apply to managers who are not directors of the company. Note that when applying the law relating to directors' duties, the courts do not distinguish between actions of a director as director and actions as manager, where the director is an executive. Those duties will apply to both aspects of the director's activities. Therefore, some actions by senior management of the company, provided they are also directors, will be subject to the controls of the general statutes. So go to your act and tell me what does it say about being an officer? Because remember, the act didn't define director, but it gave you the common law duty of a director. So who are officers under either statute? Do they speak of officers?
This is 54.
I remember reading that. And then the company? Hmm? Let me see if you're the old one or the new one. New one, yeah, 110, designation of officer. Mm-hmm. Okay, but notice in the Companies Act, it actually defines who is an officer. No, the Companies Act only under the winding up amendments give you the definition of a shadow director. There's no definition for director under either one, only under the winding up legislation. But the Companies Act gives you a definition of who is an officer in section 2. What does it say? Who's an officer?
Means the chairman or deputy chairman of the board of directors, or the president, vice president, managing director, general manager, controller, secretary, or treasurer, and C, any other individual who performs for the body corporate functions similar to those normally performed by the holder of any office specified in paragraph A or B.
All right. So your colleague was so kind to bring us examples. And look on the back page, you will see the officers. Remember I drew it on the board in the little box? Mhm. So these are the shareholders. This is the capital, the number of shares that have been taken so far. There will be no changes. Okay? And then here, if one of these shareholders are changed, you put it in the bottom there, right? So you see how it says the names of the officers? The statute actually gives you the names. So that means that you cannot, as a company, come up with your own versions of what the names of the officers should be. Because it's actually enshrined in law how you should label the officers. Is there anything in the IBC Act?
No.
Nothing in the IBC Act?
For definition of an officer?
Uh-huh.
No.
All it says in section 54 is what? The directors of a company may appoint any person who is a director to be an officer or agent of the company, but it doesn't define it. But in 54 subsection 2, what does it say?
Subject to any limitations,
Mhm.
the memorandum or articles, or in any unanimous shareholder agreement, each officer or agent has such powers and authority of the directors, including the power and authority to affix the common seal of the company
Mhm.
as are set forth in the articles, or in any unanimous shareholder agreement or in the resolution of directors appointing the officer or agent, except that no officer or agent has any power of authority with respect to the matters requiring a resolution of the directors under section 46 of this section.
What's 46?
46 is subject to any limitations in the memorandum or articles or in any unanimous shareholder agreement, the directors may, by a resolution of directors, fix the emoluments of directors in respect of services to be rendered in any capacity of the company.
Mm-hmm. So what is it telling you now? What powers does an officer have? What powers? Does an officer and a director have the same powers?
Yes,
Mm-hmm.
yes.
Mm-hmm. They do. Because look at the definition.
Mhm.
The definition of an officer is who? Chairman, deputy chairman of the board, the president, the vice president, the managing director, the general manager, the controller, the secretary, or the treasurer. And who are they normally? All senior management.
Mhm.
So they're the officers. The fiduciary role, duties, and responsibilities of directors and officers in the management of companies are significant and pervasive. The challenges of good corporate governance, increasing shareholder rights, improper actions by directors, and the pervasive legal liabilities of risk exposure to directors for the performance and propriety of companies make it more challenging for directors to clearly define their roles in this changing environment. As recent case law has reflected, the ambit of directors' fiduciary duties extend also to shareholders, creditors, and employees of companies, making the expectations, responsibilities, and accountabilities of directors that much greater and more demanding. These duties are important reminders to directors of their need to be prudent, proactive, and precautionary in their roles as directors, whose decisions and actions are increasingly under scrutiny by their stakeholders, courts, and the public at large. Isn't this a good topic? I know y'all like this one more than Jazz,
Yes.
but don't worry, I have my Jazz question ready for y'all. I have it. Ready. Let me see that I was supposed to look up something for you all on, what's it, Enron, but I got sidetracked. But I do have my financials questions ready.
So the final,
Mm-hmm.
okay, so the final will be from the chapter we left off? Or
Yes,
do you-
ma'am.
Okay, so we ain't gotta worry, but the first four chapters.
Mm-mm.
Okay.